Florida averages more than 30,000 commercial truck crashes every year. Of the serious injury claims that go to litigation, fewer than 5% of injured victims fully understand what the process actually looks like before they're already inside it. By the time most people figure out what's happening to their own case, the trucking company's legal team has had weeks to shape it. I'm Doug Burnetti. I've spent over 35 years handling truck accident cases in Florida courts. And what I tell every client on day one is this: the process isn't complicated, but has to be understood before it starts. Let's get into it. By the end of this video, you will know every phase of a Florida truck accident lawsuit from the day of the crash to the resolution of the case, and you will know the specific points where trucking companies apply the most pressure. That knowledge changes everything about how you respond when it matters. The investigation phase, what happens before any lawsuit is filed. A Florida truck accident lawsuit doesn't begin on the day you file. It begins on the day of the crash, and the side that understands that first has the advantage. Before any complaint is drafted, the foundation of the case is built or lost in the investigation window. That means collecting the truck's black box data, the electronic logging device records, the driver's personnel file, the carrier's maintenance logs, and any dash cam or surveillance footage from the corridor where the crash occurred. Under the federal regulations, FMCSA, carriers are required to retain driver qualification files for a duration of employment plus 3 years. Those files contain driving history, prior violations, and training records. They exist, they are relevant, and they don't get produced voluntarily. Think about this. A family retains an attorney 2 weeks after a crash that killed their father on I-4 near Orlando. By the time the preservation demand goes out, the carrier has already completed its own internal accident review. The company's report concludes driver error was minimal and road conditions were a contributing factor. That internal report was drafted in the first 72 hours. The family's attorney is working from a 2-week deficit before the case has even been opened. The investigation phase isn't a preliminary step. It is the case. The most important thing you can do in the investigation phase is get a written preservation demand to the carrier, the driver, the leasing company, and any cargo contractor within 72 hours of the crash, and sooner if possible. If you're already past that window, call an attorney today. Some evidence can be recovered through third-party sources. None of it gets easier to recover as time passes. Federal regulations, the layer some attorneys miss. Florida truck accident lawsuits operate under two parallel legal frameworks at the same time. State tort law governs negligence, damages, and comparative fault. Federal Motor Carrier Safety Administration regulations govern the driver's conduct, the carrier's obligations, and the equipment standards the truck was required to meet. A violation of an FMCSA regulation is negligence per se under Florida law. That means the violation itself proves fault. You don't have to argue what a reasonable driver would have done. The federal standard already answered that question. I once had a client who was rear-ended by a fully loaded 18-wheeler semi-truck on Suncoast Parkway. The defense's initial position was that the driver had applied his brakes but couldn't stop in time due to the wet road conditions. When we pulled the truck's inspection records, we found the rear brake adjustment on 2 axles was out of federal compliance at the carrier's last DOT inspection 3 months before the crash. The carrier had flagged it internally and deferred the repair. That deferred maintenance report was the turn in the case. The defense's road condition argument collapsed entirely. The case resolved at a number the family hadn't believed was possible. Now, we don't always get a smoking gun like that, but the only way you'll know is if you know what documents to request and what documents to ask them to preserve early. Before any demand letter goes out in a Florida truck accident case, the full FMCSA compliance history of that driver and that carrier needs to be on the table. Hours of service records, inspection histories, violation logs, and safety ratings are all publicly accessible through the FMCSA's safety measurement system. Pull them before the first negotiation. What's in those records often determines whether this is a policy limits case or a defense verdict. Filing the lawsuit. Timelines and what the complaint actually does. Under Florida's current statute of limitations, you have 2 years from the date of the truck's accident to file a lawsuit. The deadline was cut from 4 years by House Bill 837 in March of 2023. The complaint itself isn't the aggressive move that most people imagine it to be. Filing formally opens discovery, which is the process that forces both sides to exchange evidence, answer written questions under oath, and produce witnesses for depositions. The complaint is the key that unlocks the discovery process. The evidence inside that process is where cases are actually won. The trucking company's legal team is not surprised when a lawsuit is filed. They've been preparing since the day of the crash. What changes at the filing stage is that they can no longer control the evidence themselves. Subpoenas can compel production of records they haven't volunteered. Depositions can put the driver, the dispatcher, and the safety manager under oath. The playing field doesn't level entirely at the filing stage, but it levels significantly because we can start subpoenaing records, documents, etc. Florida requires a pre-suit demand before filing in most personal injury cases. The demand letter is not a formality. It sets the factual and legal framework the defense will respond to, and a poorly constructed demand can undervalue a case before litigation even begins. The demand should reference every applicable FMCSA violation, every identified defendant beyond the driver, and every category of damages, including projected future damages. What isn't named in the demand is a little bit harder to introduce later, although once you file suit, things do change. Discovery and depositions, where the case is actually built. Discovery in a Florida truck accident lawsuit typically runs 6 to 12 months. During that window, both sides exchange documents, answer interrogatories in writing, and take depositions of key witnesses. The depositions that matter most in a commercial trucking case are rarely the drivers. The dispatcher who communicated with the driver in the hours before the crash, the safety director who reviewed the driver's prior violations, and the maintenance supervisor who signed off on the last inspection all sit at the center of the case. Their testimony either supports the carrier's defense or it doesn't. Here's what that looks like when it breaks the right way. A driver rear-ends a passenger vehicle in a construction zone on Interstate 75 in Florida. During discovery, we depose the carrier's dispatch manager. Under oath, he confirms that the driver called in a fatigue complaint at a rest stop 2 hours before the crash and was told by dispatch to continue driving to make a delivery window. That call was logged. The log had not been produced in initial discovery. We found it through the deposition. That testimony supported a multi-million-dollar resolution. The driver's deposition was almost irrelevant by that point. Go into discovery expecting that the most important evidence in your case hasn't been produced yet. The trucking company's legal team produces what you're required to produce. Your attorney's job is to identify what's missing and compel its production before the discovery deadline closes. Mediation, settlement, and the decision to go to trial. Florida courts require mediation in most civil cases before a trial date is set. Mediation is a structured negotiation facilitated by a neutral third party. It is not binding. Either side can walk away. But in commercial truck accident cases, the majority of cases will resolve at or a little while after a mediation stage because the discovery process has by then produced enough evidence that both sides have a pretty clear picture of what a jury would see. The question at mediation is not always who wins. The question is what that win is worth and whether the certainty of a settlement outweighs the risk of a trial verdict. The decision to accept a settlement or proceed to trial is always the client's decision, never the attorney's. What an experienced truck accident attorney provides at that stage is the honest assessment of what a jury in that venue, whatever county it is likely to do with the evidence. Hillsborough County juries and a Duval County jury can reach meaningfully different verdicts on identical facts. Venue matters. And when I say venue, I mean the county in which the case is filed and tried. The composition of the jury matters. And the strength of the evidence the discovery process produced over the prior year is the single biggest factor in where a settlement number lands. If you are in active litigation on a Florida truck accident case and mediation is approaching, make sure every category of your future damages has been documented in writing by your treating physicians before you walk into that room. Future medical costs, projected wage loss, and permanent impairment ratings require expert documentation to be included in the settlement calculation. A future cost that isn't documented at a mediation is a cost the defense will argue doesn't exist. Now you know how the process works, but there's a question that comes right after this one for almost every truck accident client I've ever had. What is a case like mine actually worth? The process matters, but if you don't understand what drives the settlement number, you won't recognize a fair offer when it comes. Watch what's the average settlement for a semi-truck accident in Florida right now. See you over there.